and welcome to my Anti-Money Laundering presentation, where hopefully in the next 10 or 15 minutes I'll give you an insight into what your obligations are under the regulations and what HMRC are expecting of you from a compliance perspective. So, a state agency is regulated. The money laundering regulations regulate a number of business sectors, but a state agency was brought into it some years ago, and more recently HMRC became the supervisory authority for a state agency. So they're the people that will be checking up on you, they're the people that you have to register with, etc. The first thing you have to do, register with HMRC before any estate agency instructions are taken. As soon as you act as an estate agent, you must be registered with them. There are a number of agents who've retrospectively registered, and if you do that, then you have potential penalties. You will also have to pay the back registration fees that you should have paid, so therefore, making sure you register immediately before you start in business is a great idea. If, however, you're already in business, then you will have to tell them that you have been trading and not been registered, at which point you will have to pay the penalties that apply. You have to register every branch that you trade from, not just the head office, and there's a renewal fee annually payable. If you make any changes to your business, then again you have to inform HMRC, and you've got 30 days to do that, or else penalties will apply. You must have a money laundering reporting officer. I'm hoping that you all do and that you all know who that person is, because they're the most important person in your business as far as money laundering compliance is concerned. The role of the money laundering reporting officer is very significant. So first of all, it should be somebody with some real seniority within the business. Don't appoint an administrator, don't appoint a part-time negotiator as your money laundering reporting officer. That will not comply, and you will have problems with HMRC if you try and do that. Money laundering reporting officer are the decision makers, and they decide whether suspicious activities, or SARS, suspected activity reports, are going to be made to the National Crime Agency. Every case has to be considered on its merits, and the money laundering reporting officer has to outline the reasons for not making a report if they decide that that's the route to take. If you make a report, you don't need to document the reasons for making a report. You'll have done that when you make the report. But if you decide you're not going to make a report on a particular situation, it needs to be documented so that if it's ever questioned, then you can say we didn't make the report on these grounds. They are personally responsible if they fail to make a report, and they should have made the report, so very important that money laundering reporting officers are aware of that. But once a report has been made, the money laundering reporting officer then has no more obligations with regard to that report. The obligations then fall onto the business, and we'll talk about what their obligations are once a report's made in the next few minutes. HMRC require you to have a money laundering policy in place. It's not a difficult document to draw up, it's just a policy document that you should have. You also need to have a procedures manual or an instruction manual outlining what you expect of your staff within the business with regard to money laundering processes. You need to have carried out a business money laundering risk assessment. HMRC will expect you to have done that, so that you know whether you're a high-risk business for money laundering or low-risk business for money laundering. The more properties you sell where it's owner-occupier, the lower the risk you will be. The more properties you have where maybe your clients who are selling live abroad and buy and sell properties in the UK, the higher risk you'll be. You also have an obligation to train all your staff. That obligation comes from Regulation 21 at HMRC, that you must do that at least every 2 years. You also should be auditing your ID records, probably annually, but you can do it more often if you like, to ensure that your staff are obtaining the correct ID from clients. they're not obtaining the correct ID from clients, then you need to know about it and you need to take some action to make sure you are, because HMRC will check your records of ID. If you haven't got the ID, there's penalties that follow. And an annual review of everything you do should take place annually. Now, quite often, an annual review will mean that nothing changes because nothing has changed within the business. But at least having something maybe in the minutes of a directors meeting to show that you have reviewed it and nothing needs to be changed, everything's in order, is a very useful thing to have in place. The National Crime Agency are the people that you make reports to. If you've got a suspected activity report, a SAR, then they consider the report and they check the information that you provide to them against various databases. Details of any suspicious activity are then passed to the relevant authorities, which might be the police, because it might be a criminal action that the police enforce. It might be a tax evasion issue where HMRC themselves get involved, so it will be passed to them. It might be trading standards, because it might involve some sort of trading standards legislation like counterfeiting or something, some aspect of that nature. So they will pass that information on to the relevant authority. The job of investigation then lies with that authority, and all those investigations are kept confidential. And if you want to proceed with any actions for a client after you've made a report, you've made a SARS report, now what do you do? Well, basically you have to obtain consent from the National Crime Agency to carry on any work once you've made that report. And here is a bit of a flow chart which shows the process. So a member of staff makes outlines a concern to you about a client where they suspect money laundering might be involved. If we go down the left hand side, then the money laundering report officer decides not to make a report. They decide it's not suspicious and therefore they don't make a report. Keep a record of the reasons for that decision, and then you continue to act for the client in the normal manner. However, if it goes down the right hand side of this chart, then you decide to make a suspicious activity report to the National Crime Agency. You must suspend all activity in relation to this client and the transactions that are involved. And the period that you have to suspend activity is 7 working days, or until the National Crime Agency provides you with consent to continue. If you get those two situations, whichever one comes first, so you don't hear anything for 7 working days, you can then continue to act on behalf of the client. If the National Crime Agency provides you with consent to continue, quite obviously you continue. If the National Crime Agency refuses consent, and they'll do that to you in writing, then there is a 31-day moratorium, which means you can't do anything for a further 31 days. If, however, the National Crime Agency provides you with consent to continue within that 31 days, then obviously you can continue to act for the client. If the National Crime Agency refuses consent to continue, then you must permanently stop all activity in relation to that client and that transaction. In those circumstances, there will be various court orders obtained that will be issued to you that will prevent you from taking any further action in relation to that transaction or activity. So that's basically the flow chart, and if anybody would want a copy of that flow chart, they can send me an email and I'll send them a copy of the flow chart. Email me at david@compliance-matters.co.uk and I'll send you a copy of the flow chart. Just to clarify the time limit situation for you before we move on. No activity for 7 working days, or until the NCA come back to you and say, yes, it's okay, that you can carry on. If, however, the NCA come back to you and say, no, you can't carry on, you will then have to stop any work for 31 days. If 31 days passes and you hear nothing, then you can carry on working for the client. If they come back to you and say you can carry on working for the client, obviously you do. Alternatively, you will get a court order telling you that you cannot continue with that transaction. You can ask for a fast track for urgent cases, which will be a lot of estate agency cases, which will then mean that the NCA will look at it and get back to you very quickly. And generally they get back to you within a couple of days if you ask for it to be fast tracked. Now let's talk about customer due diligence, which is obviously something that's close to the heart of Ethos. The timing of your ID checks is very important. The regulations say that you mustn't enter into a contract with a client unless you verified their ID. There is an exception allowed under the regulations which works quite well for agents. I wouldn't want you to take this exception as being the rule. I think it can apply and you're allowed to use it, but it shouldn't be the norm. If it's necessary not to interrupt the normal conduct of business and there is little risk of money laundering, you can obtain ID at a later point once you've started to act for a client. However, you still have to obtain the ID and you still have to do that very quickly after you've taken those instructions. But in many cases, you might end up losing the instructions if you weren't to take them on the day that you did the valuation. So therefore I think this exception does apply in your case. Once you've got your ID, whichever route you take, you can obviously take a route which says we're going to see the originals and keep copies of them and all the issues involved as far as that's concerned, or you can take the electronic route which would be through Ethos. It depends on what works for you, but you have to do one or the other. Once you've done that, then you must keep your records for 5 years. That's from the time of completion of the last transaction for that client. Just remember that this ID check has to be done for every single client that you get, whether it's a owner-occupier, whether it's someone with a power of attorney for a particular seller, whether it's a will situation where you're acting on behalf of the executors of a will, whether it's a partnership that you're working for, or whether it's a builder, whether it's a London listed stock exchange company. It doesn't make any difference. You will have to still carry out customer due diligence and keep those records for 5 years. So we have got quite a lot of obligations on estate agents. I hope I've made it fairly clear to you what you need to do. If you need any help with compliance, then we Compliance Matters provide compliance packs which help agents solve that problem. And if you need anything, then you use the email address that I gave you earlier on, which is david@compliance-matters.co.uk, and hopefully I'll be able to help you out. Thanks very much for your attention.